Hi, I'm John Chichester. This is On the Constitution. Today I've got with me constitutional attorney and professor, formerly of Hofstra University in Uniondale, Long Island, Frank Scaturro. Hi, Frank.
Hi, John.
How are
Great to be
you?
here. How are you?
Let's get into what is the Constitution exactly?
Well, the Constitution, you could say, is our national blueprint. It's a document that was ratified very early in our history that sets the supreme law of the land. After the United States, after the colonies broke away from Great Britain during the Revolutionary War, 1776, our founders tried to cobble together a new government that would work for these colonies that were just transformed into the United States. For years, there was an attempt to govern the country under what was known as the Articles of Confederation. It did not work. It was too fragmented. It was too cumbersome. You couldn't get anything accomplished. And so the framers put together, they actually had a constitutional convention in Philadelphia in 1787, and they decided to craft an entirely new document, a new charter to govern this country. That was the Constitution that we know.
Now, what exactly is the Constitution? It's law. We know that.
Mm-hmm.
What does it mean to us, though?
Well, what it should mean to us is that this is a government not of laws and not of men. We're governed by principles. We're governed by a set of rules. And that's one of the things that separates us from many of the tyrannies of old. The Constitution sets out what the powers of government are, particularly the federal government, but it also sets out those limitations. It gives us a government of limited powers that confers on the federal government a certain sphere of authority, but it reserves others to the states and to the people. And an interesting thing about our Constitution, what was ratified in 1787 dealt overwhelmingly with the structure of government, that there would be a president, there would be two houses of Congress, there would be a judicial branch, that each of these branches would be able to have checks and balances on each other so that no one branch became too powerful. But it didn't say terribly much in the realm of individual rights. Well, right after the Constitution is ratified, there's a debate over whether this document should in fact protect individual rights. So in 1791, just 4 years after ratification, the first 10 amendments of the Constitution are ratified, and we know particularly the first 8 of those amendments as, all 10 are the Bill of Rights, but the first 8 actually protect individual liberties like the freedom of speech, press,
Right.
Religion, and so forth. It was an afterthought, yet it winds up being one of the most litigated and best known aspects of our Constitution today.
What I understand that, as I always understood it, the Constitution is basically, it gives enumerated powers to the government.
Mm-hmm.
This is what the government can do.
Mm-hmm.
Anything that is not enumerated, the government can't do. Is that correct?
Yes, that's the way the Constitution was conceived. Of course, if you talk about court cases over the years, there has been a lot of expansion, a pretty broad interpretation placed on the powers of the federal government. But as the Constitution was conceived, as it's written, the federal government is one of limited powers.
Well, I don't know. I know that the government is now into basically every single aspect of our lives.
Yeah.
There's no activity that you can engage in without the government peering over your shoulder.
That's right.
It seems to me that the two specific areas of the Constitution are constantly under debate. That is the what was it, the Best Interest Clause?
I mean the General Welfare
General
Clause?
Welfare
Yeah.
Clause, yes. And the Commerce Clause.
Mm-hmm.
Would you explain to us what the problem is with this, or how this is debatable?
Well, at the time of the Constitution's ratification, among the powers given to Congress was to tax and spend for the general welfare, and also to regulate commerce among the states. This is among several powers that are enumerated in Article 1, Section 8, but the Interstate Commerce Clause has, as it's become known, has become a matter of great controversy because it has become the source of the authorization or the claimed authorization for so much of what the government does. Now, initially, the concern that the framers had was of trade between the states. You did not want states to put up tariffs, for instance, or barriers that would inhibit the flow of goods from one state to another.
So it's to encourage commerce.
Right. But over the years, issues arose before the court about how much commercial activity can in fact be regulated by Congress. The court developed, I think, a reasonable rule that which substantially affects interstate commerce can be brought into play, can be regulated under this clause, especially when you look at it in conjunction with the necessary and proper clause. But there came a point during the New Deal when the court was striking down a number of programs that Congress was passing into law, that the court seemed to employ such an expansive notion of what substantially affects interstate commerce that you could arguably say it didn't matter how substantially something affected interstate commerce. It could be something really quite tenuous. It would be okay to regulate it. One of the notorious cases that comes up, it's still good law, but it comes up in every constitutional law case, is Wickard versus Filburn. That involved a challenge to one of the agricultural regulations imposed during the New Deal.
Is this the farmer who was growing wheat to feed his own cattle?
That's right. In fact, he was not doing, he was just storing the wheat in a silo. He wasn't putting it into the market at all. And yet he was considered, regulated. He was subject to the regulations of the Agricultural Adjustment Act, I believe it was being challenged.
It seems to me the idea was that because he was growing wheat and he wasn't entering that wheat into interstate commerce, he was affecting interstate commerce.
Yes, they said the decision not to put this wheat into the flow of the market was itself something that affected interstate commerce. And so after Wickard versus Filburn, a lot of constitutional law scholars thought, wow, the court is going to allow Congress to regulate everything, that they'll find no limits to what they can do under this clause. And in fact, you have a lot of stuff. Environmental regulation, drug laws are basically, they all fall under the Interstate Commerce Clause. Now, if you fast forward almost 60 years after the last act had been struck down by the Supreme Court in the 1930s, fast forward to 1995, the court faces a situation in a case called United States versus Lopez, a ban on the possession of guns in school zones.
Right.
Now, as a general proposition, if you suggest to people that guns shouldn't be carried around what are designated as school zones, not very controversial.
Right.
But our Constitution makes it clear that there are certain levels of government that have certain jurisdiction, and that this is not a power of the federal government. At least that's what the court had decided by a 5-4 margin. It surprised a lot of people because it was the first time in nearly 60 years that the court had set any sort of limit on the Interstate Commerce Clause. They said the possession of a gun in a school zone is just not sufficiently economic, it's not sufficiently related to commerce to fall within Congress's power. And then a few years later, the court reached another decision that struck down aspects of the Violence Against Women Act, saying that the activity that was regulated there was not sufficiently economic. You're not really talking about commerce. But despite those opinions, you do have still a very expansive notion of regulation of interstate commerce that's permitted by the Constitution. In 2005, I believe it was, the court decided a case called Gonzalez v. Raich that involved somewhat parallel to the Wickard v. Filburn case. There was someone who was growing marijuana on her own property in California. And the question was whether the federal drug laws reached this activity. She wasn't selling it, she was growing it for her own use, and this is not to say anything about whether this is an activity that should be regulated or not.
There's no commerce involved.
But there's no commerce involved there. But the court nonetheless decided under the case law, including Wickard v. Filburn, that yes, this is in fact legitimate regulation. So they upheld that regulation, that application of the Commerce Clause. So there's not, when you ask how much is there, how much is Congress limited from regulating, under the court's jurisprudence, it's a pretty small area. And now this becomes a big problem when you turn to Obamacare, because the health care legislation that was passed last year, for the first time in our history, imposes on consumers the obligation to buy something, to purchase something.
To enter into a contract with another private entity.
Basically, yes, to purchase a product. When you ask what is it that's being regulated, usually when you think about commerce, or when you think about those things that substantially affect commerce, you'd presumably be talking about some sort of activity, that you are doing something, and that's what Congress is trying to regulate. But in this case, the argument against it, which I think is a compelling argument, is that people are not doing anything. I mean, how can you regulate inactivity?
Right.
You're not even growing grain and putting it in your own silo, or the woman with the marijuana plants. You're doing nothing. So how can Congress come in and regulate this
You're
this
basically
activity?
placing a burden on somebody just because they have a heartbeat.
Yeah.
You're saying that you must do this.
In fact, you're almost regulating the very thought that a person has not to purchase health insurance.
Right.
Whatever judgments you want to make on it, whatever the states or local governments want to do, they do have a lot more power in this area. But I think there's a reason, although the lower courts have gone both ways on this, I think there's a reason that you have several judges who've already declared this unconstitutional. I think this case is headed up to the Supreme Court, and it'll be a very close call how the court decides it. I think it could go 5-4 in either direction.
Yeah. And that's the problem sometimes with the Supreme Court, is you wind up with such differing views of what is or what is not constitutional within the 9 justices. We're talking about 9 guys with robes.
Yeah.
You know, and these 9 guys, an oligarchy, if you will, can basically write the law of the land based on the cases that come before them. All they have to do is make precedent with case law, one decision, and they can do anything, basically. Change whatever they want.
Yeah, it's an unfortunate, I mean, to some degree, of course, it's necessary. You need a court there, but the former Chief Justice Charles Evans Hughes just said, well, what's the Constitution? It's what we say it is. And of course, he didn't mean to be quite as glib as the quote strikes us today, but the court has gone into so many areas of our lives that, yes, in some cases, there are some serious issues that call for its intervention, but I think there's also a perception that the courts have become too politicized, that there's not enough that they're leaving to the people.
All right, Frank. Seems we're out of time this time. What I would like to do, though, is I'd like to invite you back. I'd like to have more discussions.
That would be great.
With regard to, and to learn from you about the Constitution, a subject a lot of us have very little knowledge of. So this is On the Constitution. I'm John Chichester, Frank Scaturro, and we'll see you next time. Thank you.
Thank you.
Looking in your eyes, I see a paradise. This world that I found is too good to be true. Standing here beside you, want so much to give you this love in my